Hi, all. Today we're talking about the federal contours of regulating local problems in policing and other violations of local rights. As we start off with the first week, what exists largely to regulate violations of personal rights by police and others in government is the vestiges of the Civil Rights Act of 1871, often called Section 1983 for the part of the Civil Code where it's now listed. In its origin, as Gene Nichols notes, a lot of the focus was on the failure of state courts. When you look at what the federal government often wants to do, is to move judgments of police failings out of state courts and into federal courts on the assumption that state courts, because of who's appointed them, because of local corruption, because of local pressures, because of who's being put on local juries, that those courts will not protect those rights. As they note, many federal legislators, when the 1871 Act was written, assumed that many judges were in league with the Klan, either explicitly or implicitly on the crimes they'd allow to happen. At best, most local courts at the time were afraid of the Klan, and there's always been the ongoing fear that local state courts would be intimidated and give in to the will of often largely white juries in many communities and not enforce rights, especially in periods where the right of blacks to vote was suppressed. Nathan Pittman gives a little bit of the history of how Section 8 1983 was revived, because for almost a century, it was largely a dead letter. There was almost no federal intervention to stop abuses. And it was only in again, largely under the Warren Court that it was revived. I mean, yes, the statute was passed under Reconstruction, but it was only with 1961, in the case called Monroe v. Pope, that in the phrase, it was awakened from its long post Civil War sleep via that Supreme Court decision. Now, it wasn't a broad reopening, but as the court said, the Congress has the power to enforce provisions of the 14th Amendment against those who carry a badge of authority of the state, i.e., they're still not willing to go after private action, but when somebody is vested with the authority of the government, police officer or others, there's going to be some realm of accountability. Now, in follow up cases, as he explores, there were a number of cases, Henry v. Purnell, Torres v. City of Moderna, where appeals courts and other courts looked at the use of, when a person was killed, how are you going to look at the basis for Supreme Court precedents for how to hold people accountable? And here's the key part. It isn't just about a rogue cop. They wanted to look at what was the nature of an officer's training? Were they acting in accordance with the training they had? What was the danger they were experiencing? And how did the victim contribute to the mistake? And there's a whole history of excessive force claims. There is, for example, this is an earlier one, you couldn't put a tube into a stomach to induce vomiting to find drugs. That was actually one of the earliest cases from 1952. This was along a sort of general idea of does something, quote, shock the conscience of later cases. There were other ones where in Graham v. Connor in 1989, what they tried to do was develop some degree of guidance. And they wanted what was in the end a very intensive review from the severity of the crime, the threat, whether they were actively resisting or evading arrest, you know, but that reasonableness standard still remains so nebulous that it left Section 1983 largely impotent. Now, you've often heard in the news what's called qualified immunity. And this was born in the case of 1982's Harlow v. Fitzgerald. Now, in some ways, qualified immunity is better than no immunity. But the idea is you look at what they say is the objective reasonableness of actions by the official. And essentially, the official is shielded from liability if they act on basis of what a quote reasonable person should know. Essentially, this creates some sense that if the officer can claim some ignorance of the law in some cases, they may be protected from liability. So this has been seen as an ongoing problem. I mean, Michelle Alexander tried to look at some of the alternatives to Section 1983 that civil rights litigators looked at. Back in the early 90s, the city of Los Angeles became notorious for using chokeholds against victims. There were lawsuits over this as a violation of constitutional rights. But in the Lyons case, the Supreme Court said, Mr. Lyons probably can't claim that they're likely to face a chokehold in the future. So, under the grounds of what's called standing, the action might be illegal, but they didn't have the standing in an active controversy to sue over it. So that largely shut the door over accountability on what was many saw as a technicality. The court's ruling in Lyons made it extremely difficult to challenge systematic race discrimination in law enforcement. There were other cases where the Supreme Court ruled that states and its offices couldn't be sued in federal court because of the 11th Amendment to the Constitution. And the state can't be sued for damages for constitutional violations in state court easily, creating even harder barriers to getting involved. Court has ruled that a city police department can't be sued for damages unless a specific city policy or custom can be identified in authorizing the illegal actions. But the Supreme Court has indicated that in policing, race can be used as a factor in discretionary decision making when that discretion is tied in with the crime itself. This came into a head in United States v. Brigoni Ponce, where when looking at decisions to stop and search at the border, the race, a person looking Mexican appearance, could be taken into account of reasonable suspicion to stop the car. The problem is race is rarely the sole reason for a stop or search. So if you say you can use race as long as you have other reasonable reasons for stopping them, there's usually some reasonable reason you can come up with. So the problem is there's been so many studies on bias of driving while black, where black motorists are stopped at far greater numbers, greater percentages of the time than whites, despite the fact that blacks and whites, by other measures, violate traffic laws at almost the exact same rate. There's a whole range of those, and it's really has come up. We saw this actually in the dissent when they were talking about Atwater, where Justice O'Connor brought up these studies to say why you didn't want to allow arbitrary arrests. The Diallo murder in New York City was one of the more shocking versions of police brutality, illegal, killings, that it created a whole set of studies that showed the kinds of disparate treatment in litigation and in policing. Now, but still, there were lawsuits that were going forward to challenge disparate treatment. But in another case called Alexander v. Sandoval, which was litigating under the Civil Rights Act of 1964, that said the government can't fund racist institutions like a police department, again, the court said, however, there is no standing by individuals to sue under that section of the 1964 Civil Rights Act. So while it might exist on paper, it didn't give much option for individuals to hold police departments accountable when they suffered damage. Which brings us to the Floyd decision. The Floyd decision, which was largely a local federal court, but it used much of the research that came out of the Diallo killing had a 9-week trial and found, based on a whole range of evidence, key facts: the New York Police Department had made 4.4 million stops in a stop and frisk manner between January 2004 and June 2012. 80% were among of blacks or Hispanics, and more than half the time the suspects were subject to a frisk. Now, the problem was they said that this was not done always with the reasonable suspicion required under the Terry standard, but also was done in a racially disparate manner. The court, in the end, did find that this violated the Constitution. Not that stop and frisk was made unconstitutional, but the manner it was done in New York, in the systematic way it was done, was applied in a racially disparate way, that a lot of the time the frisk did not have the reasonable suspicion required. And you can go through the case, but the stats were very strong in this. Like a weapon, you know, 8% of all stops led to a search into a person's clothing, and 9% of the searches, the object was a weapon, but 91% of the time it was not. If this was about the expertise of the police, they were doing searches of millions of people without finding anything. And the point was, weapons were seized only 1% of the time with black people targeted, but 1.4% of the time in the case of whites, yet whites were being searched far less. So there was far more searching of African American, Latino suspects, even though there's no evidence that whites weren't armed or had other contraband that was being looked for. So the legal findings was that, first, many of the stops, 200,000, didn't even list a reasonable suspicion. But the key overall was not that there were individual cops, because there were so many millions of searches. It wasn't about individuals doing it. It was that the NYPD leadership had, quote, deliberate indifference to constitutional deprivation of rights. And they noted that there were reports as early as 1999 from the New York Attorney General telling the city, you're violating people's rights. They argued there was policy encouraging racial profiling, and most telling, there was no attempt by the leadership to track whether civil rights, civil liberties were being violated. That indifference to violation of rights was where they found the problems. And this went to the level of liability under Section 1983. Another key case was what was called Monell v. New York City Department of Social Services, which established that when there was deliberate indifference by high-level officials, when essentially the decision to allow violation of rights became essentially a conscious choice and not mere negligence, the cities would be held accountable. And so this was what came out of this case, that they found that under the legal standards, that this was a violation both of the Fourth Amendment and of the 14th Amendment due to the disparate treatment based on race. And so the conclusion was that because of this lack of concern and the fact that the NYPD was, through the CompStat program, tracking all measures of numbers about what was happening in precincts, but failed to measure this kind of basic issue of whether these stop and frisks were being done constitutionally, became evidence of the failure and violation of rights. And so that was where the decision went. There were appeals over it. The judge was accused of bias. They switched judges at one point. But in the meantime, there was a mayor's election. Mayor de Blasio came in 2013 and essentially agreed voluntarily, without finishing the litigation, to implement and end, to a large extent, the kinds of stop and frisk that was happening. And the result was a massive decline in stop and frisk searches, but interestingly, also decline in crime in parallel. Not so much that there may have been some relationship, but it didn't at least cause an increase in crime during that period. You know, the last year or so with some small upticks in the murder rate, but other crimes continuing decline despite the end of stop and frisk. So this was the standard that was left there, that when you look at the overall actions of a police department or other jurisdiction, that's where liability is most likely to happen and where you're going to have federal accountability for violations of rights. Have a good day.